Okay, so we're going to go through this an additional time now for some more clarity. I still maintain the basis that on the first evaluation. So we'll go through these parts because the latter ones, I know that I'm right about them, but there are some parts just so I need to make sure that I'm fully clarified. But I still stay with my first opinion. So in this part one here, there's nothing to fail to understand in this first part here. This is the judgment of the court to which both members have contributed. So that's the President and Chamberlain. On the 30th of October 2019, the respondent, Angela Ditchfield, appeared at Cambridge Magistrates Court. She had been charged by the CPS with criminal damage. She relied on the statutory defence. Well, this isn't entirely true. It says that she relied on the statutory defence. It's not only her burden to rely on anything, because the prosecution had given evidence that she had been doing activities on behalf of Extinction Rebellion, which is a political campaign to either Houses of Parliament or the King for action in matters of church, state and law. So I think she did have a solicitor, but they don't mention that. But she doesn't just rely on a statutory defence. And also, if the justices and the prosecutor, the other parties, fail to recognise her rights, which are actually evident in the evidence exhibits, that they're obvious and they're identifiable. And this document includes words including Parliament and rights and political actions. So they're self-evident in the evidence. The actual activities were an advertisement of the political cause and campaign. So it's advertising that they're using political rights. In the overriding objectives, it says that it is the requirement of all parties to recognise the rights of the defendant. It never says that it is the requirement of the defendant to recognise their own rights. It doesn't say that it's the requirement of the defendant to claim any rights. It says that it's the obligation, requirement of all parties, that is the other, or including, not the other parties, all parties, including the other parties, to recognise the rights of the defendant, not the defendant to recognise their own rights or claim their rights. So at that point, they'd all made a failure at that point. Contempt of court, an abuse of process, perverting the course of justice, professional negligence. She put a defence in. They're all entering defences and plea. They're all going with the plea and entering defences. Even though I claimed my right and had a civil hearing to have the right, they still made me put plea in. So that's wrong. You shouldn't do that. And then you've got to prove your case to a court. So they're saying that she relied on the statutory defence because they'd failed to recognise her rights, which is a critical error. Under Section 5.2 of the Criminal Damage Act 1971. Now that act treats a defence against a charge separately to claiming rights through the overriding objectives, right, privilege or interest. Now when it's in the 1971 Act, when it says a right, privilege or interest shall not be construed as a defence against a charge, it doesn't say lawful excuse. It doesn't word the right, privilege or interest with a lawful excuse, okay? If you're using a lawful excuse, that is raised as part of the statutory defence if you're being charged, okay? Now, the thing is that a statutory defence could be that if a fireman was charged with damaging a car or a building when he's trying to save property from criminal damage or being subject to arson or whatsoever, a fireman a fireman he's exercising a lawful excuse, but he's not using a privilege of Parliament. But he's got an interest in saving the fire. But parliamentary privilege is explicitly different. It's different to other rights. But usually a fireman, if he's acting with an interest in saving the fire, and he's got a legal right to act, he has a legal right to act because of the fact that it's understood that he's protecting property from further damage. So he's almost acting like a policeman in a way. He's stopping the fire from spreading. But the thing if the fire was started by someone or if it was accidental, it continues to spread of its own accord from the original incident. And so it's like a chain reaction event. So there's more and more and more and more damage being occurred. From the initial, but until they found out the reason of why the fire was started, they don't know if a person started the fire or whether it was just caused naturally. If there was an offender, there might not have been an offender who started the fire, and then you might not be acting to prevent the offender's damage because it might have been started either accidentally or whatever. But that's to be investigated. But the thing with the statutory defence is that, for example, a person, a lawful excuse. Someone might. The thing is, if someone was acting to protect something from being damaged, if someone was protecting, a brick from going through a window, and they held up a piece of perspex, and that was somebody else's perspex, and that perspex got broken, right? He's defending. He's using one item to protect another item. So protecting property and so forth, a lawful excuse. You're in that area of arguing and debate. This is where black belt barrister comes in, because it's. But I know for certain you're trying to argue out and debate it out and reason if you're challenged. The police have got to challenge you with a charge and say that you intended to damage something or do something on purpose to damage it and so forth, or you put someone in danger or at risk of danger. Well, they could say that if you were trying to stop something from getting broken, you could end up putting other people in danger and so forth. The thing with the right, privilege and interest is that it will not be construed again as a defence against a criminal charge. That's the thing. You're not defending. You're not relying on a statutory defence, because usually what they'll do is they'll recognise that if you're a fireman, it is recognised by the police that your interests are to protect. Right, and your intentions are to protect, so they won't ever accuse you or suspect you of a crime or offence. That you'll need to defend it and say that you've got a lawful excuse. One thing's for sure: firemen aren't using parliamentary privilege. That's for sure, unless Parliament's on fire. But a fireman doesn't engage in a privilege which says that you can't be prosecuted, and a privilege is not a lawful excuse. You're using a lawful excuse if you're charged and defend it and enter the statutory defence. You will argue a lawful excuse, which may be something similar to a fireman putting a fire out, or if there's a riot or something and you're protecting people, or any incident that happens, any accident or incident that happens, and you have to use something which is dangerous or use something to stop something getting broken or whatever, in that kind of in that kind of manner. Then, but it depends if you're getting charged. Who wants to charge you? Someone's got to bring a charge and accuse you of a crime if you need to defend it. Now, this is the thing: they'll usually recognize if you're recognised as having good intentions and doing something to save something, they likely won't bring a charge against you anyway. Because you've got an interest in protecting it, and because, the other person might be breaking the law and one breaking the law, not you, you have got a lawful excuse, but you're not going to argue a lawful excuse. If there are two people trying to protect something and stop it from damage, but someone complains that something got damaged, but both these people were trying to protect it, maybe they were fighting to protect it, who was going to protect it, you can end up in the situation, where people are getting, arguing their lawful excuse. I think when it comes to property, particularly criminal damage, I mean, if you're in a house and you can be in someone's house and you can spill wine on someone's sofa by accident, if that person knows that you didn't intend to do it or not, they're likely going to forgive you and not want to report you to the police because you just accidentally did it. If someone came into the house and just threw wine over it, then that's criminal damage, right? If someone is having a fight in a pub and someone is if someone's having a fight in a pub and then while someone jumps in front of someone so they don't get punched, and then but they knock some wine over and it goes on a sofa, but the pub phoned the police because there was a brawl and they said, there's all this damage, and then the police charged for criminal damage, then your person who's been involved in the incident can argue a lawful excuse that they didn't damage the sofa because they were trying to protect it, right? This is the area of law, really, that Extinction Rebellion and Just Stop Oil, Angela Ditchfield, just on a bigger scale to do with the environment, or, certain big companies or corporations are acting against the environment and they're going to cause harm to the planet, environment, or people, so therefore they're acting with a lawful excuse under this act. It's the same area of argument, mode of argument, entering these defences and trying to prove to a court or jury your reasoning. This is all this, was it proportional? Did you take, more, did you, overstep what action you should have taken? These are all black belt barrister intricate debate, really. It's basically explaining yourself thoroughly evaluating the reasons for your motivation and actions and why you did it and what you intended to do and what were your intentions and what actually was the damage and so forth. How did you move your hand, So this is like, what they're wanting to do with Angela Ditchfield, later in this document, they go into all these things about, a mental state and motivations for acting and so forth. But that's wrong, because the thing with the fireman, like I said, you don't bring charges against a fireman because it's assumed he's got the privilege of being a fireman, and he's got the right to stop when there is fire and damage occurring, which has been recognised that he's there to act so no further damage occurs, right? And that's all recognised by the police. Now, the thing is that when you've got a political campaign over matters of church, state or law to the parliament, you're using political rights. You're covered by them, and that's your privilege to have them and use them. And in the law, in the 1688 Bill of Rights and the right to petition and the Claim of Right Act, Tumultuous Petitioning Act, and in the Thomas Erskine May usage of Parliament books, you get privileges. You've got them. You're covered by them. This was the argument effectively in the Lord Hanfield case, right? You're either covered by them or not. It's effectively like you're a fireman or you aren't, right? When you put the costume on, the fireman costume, when you are using a fire engine, when you're employed, paid to do a job, and so forth, that's what you're doing. It's recognised. Now, it does, the lawful excuse does kind of even though the lawful excuse is under a defence, right? But if you've got a lawful excuse, usually you're doing something under the law. You're doing something. You're doing something, to uphold the law, right? To uphold the law or protect someone from being injured or harmed. Now, if you're not a fireman or policeman, and it hasn't been recognised that you're helping the police, if the police just happen upon some scene or incident, and they don't recognise that you had an interest, because it wasn't evident or so forth, you are going to enter a plea in a defence. Now, but the thing with the lawful excuse is that it is compatible with the rights, privilege, and interests. The lawful excuse is compatible with the right, privileges, and interests. If you put it this way, another way to say it is this: if you end up using a statutory defence against a charge and pleading not guilty, because obviously if you plead guilty, you're saying that you're a criminal and you did crime. If you enter a statutory defence and you plead not guilty, and you have a lawful excuse that you're going to argue, then the lawful excuse usually is because you had an interest in protecting or saving someone, and therefore you've got a right to act. But your rights weren't recognised or recognisable at the first instance. But the lawful excuse almost kind of loops back round to it, because you usually won't have a lawful excuse unless you had a right, privilege, or interest. But in law, the lawful excuse is not the recognition of the right, privilege, or interest. Because if you have the right, privilege, or interest, it is kind of saying that you've got a your before it's you're recognized basically. But I don't really want to go into it too much because there are other rights, like medical rights. So that could be a better example, because medical rights not necessarily a lawful excuse. So if you fall, if you faint, right, and knock something over. Let's say if you faint, or if you have a heart attack, and you fall over and break something, and you get charged with criminal damage, you end up getting charged with criminal damage. Maybe it was in a pub or something, I don't know, right? But if you fainted, you wouldn't plead not guilty and then say, "Oh, I've got a lawful excuse," because you weren't like acting to protect or save something or something, whatever, to stop someone else breaking the law. You weren't if you pass out, it's like you couldn't help it. It was a medical incapacity, effectively, a medical incapacity or a failure of you. You couldn't. So that's a right, because if you faint, okay, you've got a legal right under medical rights to, when you're unconscious, that's part of your right to not be. It's your legal right. If you're not conscious, it's your legal right to not be liable for what your body does. If you don't have control of your body, and if you can't move your body, but if someone else moved your body, right? So that's more like a right, and you've got the privilege of being unconscious, okay? So a medical right, because medical rights come through overriding objectives. So you would, if you had a medical certificate, but then again, these prosecutors probably want to say, oh, this is part of your defence, right? You don't argue. I don't think you argue lawful excuse if you feign. I don't think it's a lawful excuse, because if you've got to defend a charge and plead not guilty, and you've got to explain yourself to the court, you're defending a charge that you're a criminal and you acted criminally, but you did act criminally in order to enforce or uphold the law. That's lawful excuse. The basis of lawful excuse is more or less around you did break the law, you did do something illegal, but it was in order to enforce the law or protect someone, right? If you faint or pass out, then you aren't responsible or liable for what your body does, right? Because that is a medical right of, not being responsible or liable, and on that, it's you didn't even act. Now, if you've got a medical certificate from a doctor that says that, like if you've got epilepsy or something like that, it can be recognised, and it should be recognised more or less as if, you weren't involved in the incident, really, But these rights, privileges and interests, it definitely says that it won't be construed as a defence against a criminal charge. There were mention hearings and case stated and so forth where you can make a representation, but it's not in the capacity of under a plea as part of a defence. That has to be proved to the court or a jury beyond reasonable doubt. If you have a medical examination and it's confirmed that you did faint, right, and the doctor gives you a medical certificate that you fainted, he gives you a medical assessment, and he says, you got a certain temperature or a certain skin flush or whatever, which is a result from fainting, right? And he issues you with that certificate. That certificate is a document which is issued by the government, a qualified GP, which says that you fainted and you're not liable for your actions then at that point, particularly for things like insurance and so forth. And that would be presented to the court, and you would say, I've got proof that I fainted, and I'm not liable for these charges, right? And that would be, I would have thought, something that you didn't have to prove beyond reasonable doubt under defence. If the judge or court acknowledges the validity of the medical document, that it is a valid document, then I don't think that you have to defend the charge, because you're having a right recognised, because you had the privilege of being unconscious, and you had the right to be unconscious and not in control of your body when you had fainted. It was your right to. It is your right. You know what I mean? That's the difference. It does get confusing in a way, but it's all to do with a police. When the thing is, you're not in a lot of in these political campaign actions. They're not meant to be facing these charges, because the police officers meant to know and understand and recognise that it's obvious if they're using, when it comes to political rights and political campaigns, they're meant to know that in the first instance. So having it recognised to the court is really the last resort. They're not even supposed to bring the charge because it's illegal to be prosecuted, remember. For political campaigns, it's illegal to be treated as a criminal because the political matters of church, state and law are important matters like fighting fires, basically. And a fireman is never suspected of having intentions to do anything in bad will or malice, even though he might have to break things to protect things. You see, a fireman, even though he's got his own special equipment and so forth, on certain occasions, he has to break the law. Like he has to pick up a piece of glass and smash it on the floor, or he has to kick a door down and break something. And the thing is that the police will never charge him, ever, even though he's breaking the law, because he's doing it. He's got the interest or these interests are recognised, right? The interests are recognised. The interest to protect people, unless the police thought that he did something on purpose or with malice, Now the thing is, all matters of church, state and law are automatically to be recognised as a good cause, even if you break something like a fireman, because that's just how it is. And this is what the police don't like and can't get their head around. And really, what you're looking at with these political campaigns and causes, the fireman doesn't have privileges of Parliament, the jurisdiction of Parliament and the privilege of Parliament, and there's no law which says it's illegal for the fireman to be prosecuted, none. There's no law which says that all prosecutions against a fireman are illegal, right? So immediately, straight away, before you even start, before you even, get the police involved, matters of church, state and law are saintly. They are more important than a fireman. It might seem ridiculous, but they are in law. In law, if you're acting and wanting Parliament to act in something and you're trying to get other people to join you and sign or join in and help promote, it is automatically it's prioritised in law more than local policing at a local level and firefighting and even saving life, because at the end of the day, if you get a law changed like smoking, it could save everyone's life in the whole country if you save one smoking law. In law, without having to get the moral side of it, without having to get too much into the morals, the intention of protecting the many outweighs the requirement to protect the few. So protecting one person, who might be in a fire or hanging off the edge of a cliff, the basis in the law, without regard to anyone's opinion, it just as that's just the way it is in law, is that it's always a greater good to protect everyone, like if you're going to ban smoking or whatever, than saving one person from an incident or accident, right? That's how it is in law from the ancestors, from how they decided to make the law. And that's one thing that it's a big truth. It's a legal fact. So this is the thing when you get to recognising right privilege of interest, how you identified as a emergency services or not, are you identified as representing a campaign or cause? And remember that when all these laws were made and are still in effect, we didn't have a police force, we didn't have a proper organised body of people who are always doing this job all the time. It was a duty of the public as much to enforce the law on a local level and even protect the few than as much as protect the many and engage in political matters. And that's just the way it is. So the right privilege or interest is meant to be recognised initially, right? and in the criminal procedure rules, it overrides, because if the policeman haven't recognised it and the prosecutor haven't recognised it, then maybe the magistrates someone can understand it. It will get mentioned, and it will be recognised that all the actions and activities. You see, what's happening in these Angela Ditchfield case here is they're arguing it in the court. They're arguing, if this cause merits this action. It's like, in a way, if a firefighter does get charged by the police, and if he has, let's say that maybe there was a bank on fire and he stole some money and he smashed the safe open, right? That's a good example. He didn't, was he really putting the fire out, or was he trying to steal the money and smash the safe open? And if he smashed something on it, is that criminal damage, right? Or, if there was, I don't know, maybe a fireman started a fire and then, knew that he'd be called on it, and then it gave us an excuse. There were a lot, if there's a suspicious firefighter who could be suspected of crime while he's saving a fire, look at that. Look at some. I don't really want to use movies for an example, but look at the guy in 007. The guy in Casino Royale. That guy who goes to the airport and disguises himself as the authorities. And he goes and blows up that plane. He's trying to blow up a plane. At the airport, isn't he? And he disguises himself as, emergency staff or whatever. He's in disguise, It's in the other Bond film, you've got that bad guy who dresses as a policeman. When police, I think there's been some cases. There has been some cases in court where I think that police officer abused his position, didn't he, and stole that money in South Wales. I forgot his name now, but I was reading that case recently. That's a good example, He was pretending to go about the duties of a police officer, but he was trying to rob someone, right? So, he ended up getting charged or whatever. I think he actually ended up confessing, handing himself in. But only think because people were suspicious. But, but even if a fireman is in court and a police officer believes a fireman, broke something or smashed something or put something in danger and was trying to rob a safe or a bank halfway through putting a fire out or something like that, the court will never, they will never discuss whether the fire brigade should have been called to the fire. They won't debate if fires merit firefighting, or to what extent should firefighters use things, or they won't start to argue and debate if reasonable force was used, or if they smash too many things up. I think maybe if the police are there and then firemen aren't doing, I know that they've got to do things by how they're trained in regulation. If some of them started, but usually the police take advice from the fire brigade, and it's they don't question what they decide they're going to do or whatever. But if they started smashing too many windows, or it looked to the police like they're doing things that maybe they shouldn't be doing, or whatever. But what they'll prove though is was he doing that in order to put the fire out? What was he doing that in order to put the fire out, or was he lying about the reason that he was doing it? The thing with the Extinction Rebellion things is that, firstly, there's no one who decides. Not even the courts can't decide. What, they aren't controlling the campaign. They're not a campaign director, and they're not like a fire chief directing his crew. There is no, it's not in the jurisdiction of that court, really. It's Parliament matters. That's the main thing. It's like the Lord Hangfield. Once it was decided that it went on to those particular subjects and matters, it wasn't for the court. It doesn't matter what he'd done and why he'd done it. It doesn't matter if he had scammed his expenses or what his reasoning was for doing it or so forth. And that's the thing with the firefighting, that they're not going to say that, spraying water on fires. The court aren't going to argue that, because if they could, the thing is, all they're going to prove is, if he broke this particular piece of glass, was he doing it to get the money, or was he doing it to try to put the fire out? They would have to prove that he was doing it to get the money. They wouldn't be trying to prove that whether the fire brigade should have been called and whether they should be spraying water everywhere and whether or not all these things. It would be that specific one thing, what his intention was. And I think with Extinction Rebellion and so forth, they are intending to promote and advertise the cause in every single thing they do. There's no doubt about that. They're trying to advertise and promote the cause and raise awareness of it, and they're acting on behalf of that cause. They're not doing something. You see, if you were doing a campaign, you could be doing an Extinction Rebellion thing at McDonald's, and you could be promoting the campaign at McDonald's. But if you, put your hand in the till and take the money out, the thing with Roger Hallam, he stole money from a supermarket and he handed it out to the public. He didn't steal it himself. And he claimed it was kind of like a promo, it was like a promotional thing for his campaign. Now, was it a promotional thing for his campaign, or was he just stealing it? Well, if he gave it out to everyone else, he himself wasn't taking it to make himself a gain and put the supermarket at a loss. If he was, was it a promo stunt? A promo stunt to promote the campaign? This is the thing. If it was done to raise awareness and promote the campaign, it's not done for the reason to make a personal profit and put the supermarket at a loss. So he isn't thieving. And this is the thing, like with the fireman, if he breaks the safe to steal the money out of it, is he doing it for the reason that he's doing it, right? It's nothing to do with what damage is caused or not. Because if he is breaking that glass with an intention to put the fire out, he can break as much glass, more or less, I suppose, as he wants. Because he's got that is his lawful excuse and his reasoning. But as soon as he's doing it for a different reason to steal the money, then he's not protecting or doing it for that reason and motivation, pursuit anymore. He's doing it for a different reason, to steal, right? And this is the thing. Extinction Rebellion, because it is Extinction Rebellion and because they're promoting the campaign, it doesn't, if they're not doing it for that purpose and reason, then they aren't protected by the right. But they are doing it for that purpose and reason. And what the CPS want to do is, they want to treat the Extinction Rebellion thing, you've gone too far, you've used too much pain, you did too many things, And that's kind of like saying to a fireman, okay, you're not doing these actions to steal money. You're definitely doing them to put the fire out. But you broke too many windows while you put the fire out or whatever. If he's doing it for that purpose and reason and intentions, it doesn't really matter how many windows that he breaks, unless someone. This is the thing. Someone can challenge the police that they've kicked too many doors down. If you're going through a building chasing someone, you know what I mean? Those doors you need to kick down. Well, every single one they're closing behind me. This is the thing. There's a differentiation. There's a shift from what exactly you're examining. And this is on the parliamentary privilege. The court can't question what is going too far, or too many acts, or too many signs, or too many notices, or whatever, when it's for that purpose. Because it's not in their jurisdiction, and it's not in their jurisdiction to direct the campaign or choose what actions they do or activities they do, or even it's not even their business about what the campaign's about. Only whether they were acting for, because once you're acting for that purpose, you're covered by the privilege, and then it's not a matter for that court. And this is why and to make it easier, all this discussion and talking and all this debating and argument and all this intricate discussion. Is the right of the subjects to petition the king, and all prosecutions for doing so are illegal. Done. Right? So 4 things done for this specific purpose, matters of church, state and law, which you're trying to get, public support and opinion for and an action from Parliament. You can't be treated as a criminal. You're never seen as a criminal. It's always a good motivation, cause, like fireman. That's it. If you break something or whatsoever, then you can have civil action. But the thing with civil actions is this: an injunction serves to stop the campaign's actions and activities. Civil action is recovering money. Now, you could say to the fireman, if we're not going to treat the fireman criminally, maybe if he stole some money from a bank or it got burned, or maybe he made it look like it got burned, but he just chucked some cinders there or whatever, and you take a civil suit to get the money back from him. Or if he burned all the money, whatever, if he did it on purpose. But they're going to be insured for all that type of thing. This is the thing. But the Parliament, the fireman could be or can be criminally prosecuted. There's nothing preventing him from being criminally prosecuted in law, and he can rely on a lawful excuse if he is. But the difference is that the Matters of Church State Law campaign cannot be criminally prosecuted in law. They can't be treated or regarded as a criminal. A fireman can. A policeman can. Someone acting as of church, state and law cannot be regarded as a criminal if that is what they were doing. That is truly what they were doing. And it's not for anyone else to judge then, how many is too many stickers or not enough stickers or whatever. The court can't decide how many stickers you can and can't use, or what you can put them on with or not. You're not if they're for that purpose, it's not the court's business, and that's why we've got like the Town and Country Planning Act, which you got automatic deemed and express consent, and you don't need permission. And you can use that. You're allowed to use that enactment through it. So it's not just a lawful excuse. It isn't a lawful excuse. You're not relying on a lawful excuse because it's not illegal. It's not unlawful. When a fireman breaks glass and so forth, it usually is a crime, right? It's a crime to break it unless you've got a lawful excuse. The permission to do it for the fireman is in the town. The permission which gives the fireman an excuse to do what he's doing is in the act that otherwise you would prosecute him with, but not for the political matters of church, state and law. The matters of church, state and law, what you don't rely on the lawful excuse in the Criminal Damage Act because it's never regarded as a crime in the first place. You're barred from being prosecuted or challenged because you've got the privilege of doing very important matters. So you don't defend. You never defend it. Never. You're never defending it. And the fireman is the fireman is using the lawful excuse within that act, the Criminal Damage Act is within it for him to use it, and therefore when he's doing it and as he's doing it on site, if the police are there, because they're the ones who usually investigate or a prosecutor, no one else is going to take him to court. It's the police who, you see, the fireman is using a lawful excuse given to him within the act. Within the act, when the police turn up, they're recognising his actions and not prosecuting because he's got an interest in saving the fire. So the police aren't going to charge him when they recognise what he's doing, because it won't be construed, because he won't be regarded as a criminal. So it's all circulating in the act, whereas the Parliament privileges, with the right privilege or interest of Parliament, you can't use the act because you can't be prosecuted. It's illegal. So when that's recognised, you don't need a lawful excuse, because you'll never be construed as a defence against that charge. And to make things simpler, with the Town and Country Planning Act, when it's defacement, surface signs, notices, it's not even a crime. It's actually legal. You've got deemed and express consent to do it. Now, that's more than what the fireman gets. The fireman doesn't even get deemed and express consent. He can have a lawful excuse, and the police recognise his lawful excuse, that he's acting in his interest, and they don't prosecute. So it's it's actually what the fireman's doing is illegal, but he's got a lawful excuse for doing it, and the police recognise that. But with Extinction Rebellion and Just Stop Oil, they can't be prosecuted. It's illegal to prosecute for a criminal charge as long as they are what they're doing is for those pursuits, reasons, honestly. That's why you forfeit privileges if you lie as well. So it's not actually a crime putting signs and notices up, even wherever on bridges, as long as you're not dismantling the bridge. And this is another thing, if the public stop in the middle of the road, I'm not talking about blocking the road or standing across the road, but if you're putting signs up on these gantries that actually hold signs, they're made for holding signs in those class, in the schedules in that Town and Country Planning Act. Road signs are a scheduled class in that thing. You can do that. You've got deemed and express consent. Now, there is something about being next to a highway or so forth, but you can't have that now, because what's happened since 1971 with that, since 2007 and 1990 in the Town and Country Planning Act, is that you've got all of these big advertising boards and adverts, like those 3D cats and stuff, particularly in China. They've got all these 3D signs, and the government have said these aren't dangerous. These aren't a distraction. These can be by roads. That's perfectly okay. So if they've got deemed and express consent from an authority in council, then the political campaign can have the same consent to do it. And if people stop in the road, that is not their response and reaction. It is not the campaign group aren't accountable for anything the public does in response to their adverts, because the government have decided that, if taxi drivers stop in the middle of the freaking road in London because there's a big 3D cat on a billboard, and everyone stops in the middle of the road, and all the traffic stops, and all people get off a coach and start taking photos and stand in the middle of the road, they don't prosecute the advertising company, JC Decaux or Coca-Cola or whatever. They start prosecuting the people. If everyone stops in the middle of the road and hangs out of their car and starts taking photographs of a big 3D cat on the top of a building, then the police will arrest them and prosecute them for stopping in the road or standing in the road with a camera or whatever. They won't prosecute the billboard company or Coca-Cola, or prosecute the government or council for approving it. It's all the people who stop, they prosecute them. So when Roger Hallam is up on a motorway gantry putting a big Insulate Britain sign across the motorway, he's advertising Insulate Britain. It doesn't matter what he talks about or whether he plans if they may or may not stop. I mean, are the police in meetings with Coca-Cola listening into if they think that everyone's going to stop in the middle of the road in response to their adverts or whatever, or stop on the pavement and look at them or walk into a lamppost. If the drivers stop in the motorway when Extinction Rebellion's putting a big banner up across it, I'm not saying stood in the road, I'm talking about up on the gantry, that is installation. They got an express consent for installations, even on that bridge. This is why I'm pissed off about that infrastructure. Messing with infrastructure is dismantling a bridge or preventing the bridge from raising and lowering. It's not putting an advertisement on a bridge or on any structure or frame. That's an advertisement on the surface of a building or structure. You can do that. If everyone else stops to look at it, then the police need to prosecute them. If Roger Allam's over motorway gantry with a big Insulate Britain banner across it, if everyone, the police will have to should be prosecuting all the drivers who stop or slow down, and doing that thing with their hands, like, carry on going. Why aren't the police showing up and doing that wavy thing with their hands, wavy, get people to carry on, speed back up again or whatever, like, why aren't they in a police car on the hard shoulder with one of those light up signs saying don't slow down, just ignore Hallam, he's an uptie or something like that, pay no attention to the man behind the curtain, pay no attention. Why aren't the police on the hard shoulder, right, with the, little flip up sign on the roof of the 4x4 going, pay no attention to Roger Hallam on the gantry, pay no attention to the man behind the curtain, carry on, go, or proceed, do not slow down. That is really, I think, how the law should be, in my opinion, because that's how they're doing it in the city. These corporate entities are enjoying using money, pure money, to be almost like gods. They've got more political power and opinion than anyone else. And the thing is, if you don't do these political actions and campaigns, you end up paying. You're buying adverts in the newspaper. You're paying for billboard adverts, and all that money and profit is going to your opposition. The Labour Party don't give money to the Conservatives. The Tories don't give all their campaign money to Labour, right? To say, run us some adverts and you can profit out of it. So why should Extinction Rebellion hand all their money over to the London Evening Standard or, JC Decor or whatever it is, when they can just, you've got to buy something, I suppose, pens or whatever, but unless you're using charcoal. But this is the thing. Everything we do now, these people are profiting out of it. And this is why Extinction Rebellion are trying to use materials that cost too much money, corn flour or blackberries or whatever they're using, natural products or whatever. The courts should be commending that. You want to give us less money as possible. They're trying to do it as much as they can for free or through donated, like charities get donations. People are donating money to Extinction Rebellion. They don't. You don't. The corporate have taken over the civil sphere. The corporate have taken over the streets. The corporate private enterprise has taken over the pavements, the streets, even over the motorways. And these people who oppose it, who don't want to give money over to their opponent for them to profit out of their opposition, because then, these big companies, it's win-win. They're winning when people are buying their products, and then when you use their advertising boards, BlackRock Vanguard, they're making money out of their opponents. That's not opposing someone. You make your own signs and then just go stick them up. You don't ask permission. And when you're opposing the council and these organisations, if it's unsafe, like, these people climbing up onto some of those bridges or whatever, they're not dismantling the bridge. This is like back to the fireman argument again. The fireman is, if he's putting, the fire out, then he smash whatever windows he needs to do it. If he's breaking into the safe to steal the money while there's a fire, that's a different thing. If they're up on those towers or framework, they're not messing with infrastructure because the council put adverts on the sides of bridges. The council they put Christmas lights on the Forth Road Bridge. They have Christmas lights on bridges, Humber Bridge or whatever, and stuff on frameworks. As long as it can function and operate properly, it is serious. But if these people are, a lot of them are doing these training things and using proper clips and climbing equipment and safety ropes. If they're putting themselves at risk, they've got the right to put themselves at risk. And so forth. You don't want things blowing onto the motorway and, covering, hitting cars and stuff like that. But what you'll find is that, after you've taken something down or whatever, there is some removal from liability from it. What happens if some of these things break anyway? Are Coca-Cola responsible for, if you're on holiday in China and they've got a big cat on the top of a building and you stop in the middle of the road and you get run over by a taxi, are you going to sue Coca-Cola? I doubt it. I don't think Coca-Cola are going to get prosecuted criminally or sued. I think that the police are just going to turn up and then the taxi driver is going to get prosecuted. They're not going to take any legal action against Coca-Cola at all or whatever it is for having these big 3D board things, or if people walk into them or whatever. And that's the thing with the police and Mark Rowley, because he doesn't want to be a philosopher and he doesn't want to be reflect on it and this is too much hair. This is like, police chief just wants to, get the knuckle duster out and get down on the streets and, dust off the knuckles. He don't want to, he doesn't, this is too much thinking. It's too much for the job. It's, if the police had to do this, they'd end up being, in Parliament debating it. They don't want to. They just want to go out and do the job. This is the thing. It's and this is the problem in the courtroom. It's so. The reason why they've made the prosecutions illegal is this. So you don't have this argument in the court. You don't debate it. You don't defend it. You don't justify it. You don't justify the cause. You don't have to explain yourself. You don't have to have any, how many, stickers you put up or whatever. It's not for the court, and that's it. Tough. Now, all you have to prove is that, you were acting in pursuit of that and for those reasons. And here we've got the acknowledgement for Extinction Rebellion here, and all the rest of this paper, there's some complicated language on the last 2 pages, but I think it's a little bit like that Jeremy Johnson case paper. It's a lot of language and blagging. They've got terms in here. Case stated means that it's got to be a matter of the law or legal principle that they're calling up. But this there's some language in here which says that it says that defence was made out. So it says the defence was made out. I've just searched that term for a made out defence or defence made out, and I've just searched on Google, and there's absolutely nothing. There's no explanation what having the defence made out means in legal terms. And I've searched, the first few pages of the entire Google, and that term doesn't even appear once. They're using terms. Dame Victoria Sharpe is using terms like, having the defence made out, and there's no explanation for what that even means. Another thing with this order is that on the last page, the last part 25, it says, on the facts accepted by the justices, the acts for which the respondent faced trial could be said to form part of the tradition to which Lord Hoffman referred. Lord Hoffman referred to. But they were nonetheless unlawful. The acts against the law. Well, that's wrong. That's wrong. Because the Town and Country Planning Act makes that it's not unlawful. You get deemed an express consent automatically because you have to ask for it or apply for it because of the use of the enactment through use of enactment in Class F, which is possibly this tradition which is relied on. I don't like the fact that they're being coy with their references to lords and privileges, right? It's not actually unlawful to paint it, according to the Town and Country Planning Act. And even if it was a lawful excuse under the Criminal Damage Act is a lawful excuse to not convict them, to defend. It doesn't give you a right to do it. It's a lawful excuse is nonetheless an excuse. The privilege, a parliamentary privilege, the right to petition, gives you the legal right to do it and not be prosecuted because prosecutions are illegal. The prosecutor does not have the right to prosecute. The prosecutor doesn't have the right to prosecute when it's for matters of church, state and law, advertisements and signs. They don't have the right to prosecute. And all prosecutions are actually illegal. It's the prosecution which is illegal, unlawful. And like I say, the Town and Country Planning Act actually makes provision for it to be lawful within the law. And the thing about this is we're looking at this President of the Queen's Bench, Dame Victoria Sharpe, and Mr. Justice Chamberlain. And that's contempt of court. And it's not only Max Hill, but the judges as well. And I really can't see Dame Sue Carr removing the President of the Queen's Bench because it make the government look too bad. The honour of the government, the honour of the justice system. And then they were messing around with Assange and so forth. And then we've got all these injunctions where they're not even following the procedure rules. They're just effectively blagging it. You can't evaluate all the respondents who the injunctions against for rights if you don't know who they are. You can't check to see if they're on an equal footing because you don't know who they are. Check that all parties are on an equal footing because you can't identify them. You can't include unknown persons. If they're unknown, you don't have any evidence against them. It's all right when the prosecution says, I offer no evidence. But wouldn't it be great if you went into a criminal court in criminal proceedings and the prosecutor came in and said, I state my case, Your Honour. Here is the evidence. 3 unknown persons robbed the bank. We don't know who they are. We've got no clue who they are. We don't know what date it was, but we know the bank was robbed. I offer, I motion to convict these people and have them, do community service. Well, where are they? Who are they? Have they got any statements? No, Your Honour. You can't convict without a statement. No one can be convicted without, at least one witness. Well, do the witnesses know who they are? What's the point in having? No one can be convicted without the evidence of at least 2 witnesses. Okay, then here we have the witnesses. Are you going to give your evidence? Yes. Who are these people? We don't know. What kind of evidence is that? I don't know, Your Honour. Well, we need to be convicted on the statements of 2 persons, but we don't know who we're convicting. But yes, I saw people robbing banks, Your Honour. Oh, it's convinced. How can the jury disagree with that? There'd be unreasonable doubt the bank was robbed. By whom? We don't know. But when we do find out, we'll have them back in. But this goes for criminal proceedings as well as civil. But it's just once you understand this, I don't know who are bringing these injunctions. It's mainly councils and Transport for London, and they're using the same intelligence that we've got loads of money, you know, we're barristers, we get paid a hell of a lot of money, hundreds of thousands of pounds, we're all King's Counsel, you know, I'm getting employed by Apple to write their policy, you know, we can remove an account for any reason or no reason at all. What, even racism? You know, I remove this man's account because he's from Peking, you know, or because he is an Aboriginal, or because he's got an Australian passport, or I removed his account because he's a Muslim. You know, you can't have that though. And the reason, the other thing is that if they did remove the account for that reason, that is actually criminal and racist. And you've got there is when you're using rights, because you've got a legal right to enforce the law and arrest them, because and that would be an illegal act that you were preventing. So surely preventing an illegal act. So some of these, I don't know who's drafting up these fantasy, really kind of like pure fictional and fantasy policies in these big companies, but they're really getting carried away with themselves. I think they're drunk on money. I think they're drunk on power. I think that, you know, people like Jeff Bezos and Donald Trump, people like that, just haven't really. You know, no wonder, you know, Robert F. Kennedy Jr. is getting his, you know, case injunctioned, even though they're meant to be protected by 50C3. It's just ridiculous. It's that kind of intellect, and also Jeremy Johnson, KC as well. The reason why this is happening, it's just, it's blind to the, you know, it really is. They don't know what shapes to put in the box. You know, it's like when you get a toy and you put the star in the star and the triangle in the triangle. They're too bothered about what's written on the star, or complicated writing on it, or what's been drawn on it, or, you know, mathematical equations on the star, that they realise that they put it in the triangle box. It's literally down to that. Or they're trying to make out that it is, because they draw triangles and a star, it can go in the triangle box. You know, it's kind of that's the model of how the intellect is being employed in these legal cases, in that manner, just because they've got an extremely complicated, intricate triangle montage. It's on a star. You can't put in the triangle box, and that's it. Even if you write on it, put in the triangle box, you know, if it's a star, when it's almost like they're camouflaging the whole thing. They were not taken in order to protect property in the sense in which those words were used in section of the Act. So they didn't think that the advertisements were there to protect the property or the environment, but it's there to promote the campaign. It's nothing about protecting anything. It's there to promote Extinction Rebellion and the cause and the campaign to the public, or a section of the public. And it's there to promote the campaign and cause. And that's what the Town and Country Planning Act gives you permission to do it for that reason, for promotional reasons, to advertise to the public or a section of the public. You're not protecting or saving anything. But what you are promoting is a protected class, period. You know? And this is the thing with the Lord Hanningfield case. You see, it doesn't matter. You see, even if they did it on this basis they're trying to make out they're doing here, about whether or not it was done to protect something or not and so forth, you know, maybe it should have been struck out, but when it was struck out, the right should have been recognised as well at the same time, and she shouldn't have been convicted. That was very wrong of them to do that. So, you know, they're basically ushering people through they're failing to recognise certain things. They're doing the process wrong, and then they're even striking it out as not even being valid when they're responsible for it not being valid in the first place anyway. And the Lord Hanningfield basis was the fact that it went on to a particular subject into a particular field, and therefore it was disqualified from being heard in the court. Not a matter of motivations, what he did, why he did it, if it was protecting anything or not. It is for these, it goes on to these protected area of law, and therefore it can't be heard. And it's this exact same parliamentary privilege that it turns out we're covered by. So it has to be the same basis as what they had in that case, even though they still didn't do it 100% correct. But really, Magna Carta's kind of in effect still, really. So, the contrary conclusion was not nationally open. Rationally open to the justices, as it follows that the acquittal will be quashed and a verdict of guilty substituted. Under Section 23 of the 1981 Act, this matter will be remitted to the justices to determine the appropriate sentence. It's just getting an acquittal quashed seems ridiculous. That it's not like an appeal. An appeal against it. Why doesn't the defendant get to? This guy really is a failure. This Mr. T. Wainwright appeared on behalf of the respondent. I should get in contact with him. He really should be putting. You can actually apply to the Attorney General now for contempt of court issues, and you can also apply to get if sentences aren't strict enough, you can get him to review them. I think Angela Ditchfield's case is an understatement. There are so many reasons, without even all that fire brigade stuff that I went through. It's on the basis of what they've done with Lord Hanningfield. The Lord Hanningfield case is proof that it doesn't matter what the defendant did or the motivations for doing it or what the defence was or excuse or anything. If it goes on to these matters, then you can't hear it in the court. And the worst thing is they acknowledge that it's Extinction Rebellion and a promotion and advert. But they're saying the reason why she did it, she was trying to protect the environment by doing this act. No, it's promoting it to the public and getting more people to support it. You never question why. They couldn't question why Lord Hanningfield, did his fraud or whatever, or even if he did or didn't, because they just can't go on to it. And it is parliamentary privilege. Sir Thomas Erskine May says that it is parliamentary privilege for those matters of church, state, or law and petition. So you can't have a privilege which has had an agreed mode of application and then completely and totally change the mode of application to a completely different one, which doesn't fit the model at all, in another case. And then going about all your fanciful tradition and Lord Hoffmans and so forth, wink, wink, nudge, nudges, even though you're completely sort of in disrespect of it, really, in contempt of it. This Dame Victoria Sharpe, with the honours that she's carrying, it's going to be very difficult to get any